All right, good morning, everyone. For those who don't know me, my name is François Tanguerenaud. I'm the criminal law instructor for Section B. I'm thrilled to be here this morning and to be able to introduce to you Professor Ekow Yankah, who is really a longtime personal friend as well as a friend of Osgoode. He's been here several times in the past, and we're really happy to be able to welcome him today. So Ekow is a professor of law at Cardozo Law School in New York City, but he's not any professor of law. In fact, he was recently recognized as one of the top 50 most influential law professors under 50 in the United States. And in fact, he's accumulated many other awards honoring him as a source of inspiration in the profession. Professor Yankah is an eminent scholar of criminal law, criminal procedure, as well as one of the leading criminal law theorists of his generation. And since it's my generation, I'd say that it's a very important generation. He's published groundbreaking work in countless leading journals. He's currently working on a book on the philosophy of republicanism, civic bonds, and what it entails for criminal law and criminal procedure. Outside of the law school, Professor Yankah is active in democratic politics. He's the co-chair of the nationally recognized New York Democratic Lawyers Council, the voting rights organization of the Democratic National Committee. In this role, Professor Yankah often lobbies as well as advises elected officials and the New York State Senate and Assembly on voter protection laws and strategies to ensure every eligible voter has the opportunity to vote and have their vote count. Professor Yankah also serves on the executive board of the Innocence Project and American Constitution Society, the New York chapter. Even more notable, perhaps, is how Professor Yankah has asserted himself as one of the leading public intellectuals on critical issues related to race relations and criminal law in the United States. His razor-sharp opinion pieces have appeared in, amongst other places, the New Yorker, the Huffington Post, and other celebrated dailies. And he's also a regular guest on major TV news outlets in the US. So we're extremely fortunate to be able to welcome Professor Yankah to Osgoode today, and that he's agreed to speak to our JD class, that is you, and most particularly the first year class, on a crucial topic for the law of the United States, which, as many of you know, has some important parallels with unfolding policy issues on this side of the border. Now, when we invited Professor Yankah to Osgoode, we actually didn't know at the time that Donald Trump and the kind of overtly bigoted views that he has championed would receive a popular stamp of approval, not the majority one, I hasten to emphasize, but close to it, propelling him to the highest elected office in the United States. These disturbing recent developments, when they're juxtaposed on the vibrant Black Lives Matter movement and already tense race relations in the US, perhaps makes what Professor Yankah is going to say today on race relations, civic bonds, and US criminal procedures only more relevant, more urgent, more distressing, and not that these issues were not already so before. So our hope today is that his presentation is going to allow you to think more deeply about the kinds of issues encountered south of the border and what they mean for a society that purports to live under the rule of law. For some, they may also trigger thoughts about the situation here in Canada as it relates to our criminal justice system and what we should or perhaps should not do going forward. So Professor Yankah is going to present for about 30 minutes, which is going to be followed by about an hour of Q&A. Now, he's a very approachable man, and I really encourage you to seize this opportunity and not to be shy. So there'll be 2 microphones, and I'll be here at the front helping direct traffic. I'd also like to advertise that Professor Yankah, we're making him work for his trip today. He's also going to be presenting again at 2:30 p.m. this afternoon in room 4034 on franchise and political obligation, what we owe others foreigners and immigrants, yet another topic that merits pressing attention under the shadow of a Trump presidency and the walls that it seeks to build. So without further ado, Professor Ekow Yankah. Thank you very much.
I first just want to say thank you to Francois. Thank you to all of you. I have old friends at Osgoode, now new friends at Osgoode, and I'm thrilled to be invited here. And it's generous of you to allow me to steal your students for some time and for all of you to come join me. Oh, thank you. I'll probably need that. Francois's introduction was overly kind. What is true is that we are part of the same generation of legal scholars. And for that, I count myself lucky. He's been a terrific interlocutor and friend, and now has gone on to fancier and fancier things like being deans and this sort of thing, and the head of centers. And so anytime Francois invites me to do something, my instinct is to say yes. So I'm thrilled to be here. So today, I want to remember that not everybody here knows American criminal procedure reflexively. Of course, that's also true in America, but that means that today I'm going to be in the odd situation of telling you a story that is, one might think, equal parts politics, a little dash of history, and some law. And I'm going to try to mix these in a way that essentially tell a story. Unlike when I teach my criminal procedure class, even there, of course, there's a story that one must tell if you're going to be honest. But there's a class where one tries harder to allow some sorts of balanced views, to allow students who, after all, are going to be your colleagues quite soon, to decide what their view on the Fourth Amendment is, and to pretend to the closest thing you can get to neutrality. I don't pretend to pure neutrality, but the closest thing you can get to neutrality. Today, I'm going to not even pretend to neutrality. I'm just going to tell you my view, a very particular view, a view I think is plausible, a view I think is defensible, a view I even, dare I say, think is right. But it is my view on American criminal procedure. And thus, it's up to you and those of you who find this view unpersuasive to question me, to push me, and to push back, something to which I greatly look forward. The view I want to tell you, or the story I want to tell you about, is a story actually about how race does not affect American policing. It's a story you might be surprised to hear because it is a story that is dedicated to focusing on the way race is in fact entirely absent from American policing. It's an odd story because some of you may have the strange intuition that race does have some effects on American policing. Some of you may have seen, not just in statistics, facts, not just in demographics and institutions, but you may have now seen in spectacularly violent moments, in heartbreaking videos, and in the tears of widows and children, that race seems to be infused in American criminal law, in American criminal procedure. But oddly enough, the one place where it's actually very hard to find the story of race in American criminal procedure is in our law. It is remarkably absent. And if you're somebody who spends their time working on criminal procedure, even teaching criminal procedure, you are struck with this bizarre dissonance. You're teaching a subject which is incredibly fused from the start of American history with our odd, violent, and ugly relationship with race. And yet, everywhere you look on the text, it is very hard to find our courts grappling with it. So that's the story I'm going to tell you today, is how race has been read out of American criminal procedure and the devastating effect that has not just on the lives of people, but on communities, and on the civic bonds that we share across racial lines. That is to say, I want to remind us that the fact that we ignore race in policing isn't just painful for African Americans, Hispanics, and other minorities, but it's threatening to the project of us all living together. Now, the other thing I want to say is I have a somewhat difficult task because I've come here to at least give a story that's accessible. And again here, let me say, I do not pretend to neutrality. It turns out that between the 2 weeks I last saw Francois, the world, to borrow from Lin-Manuel's, he has a small play called Hamilton, you may have heard of it. I sure hope that guy finds some success. There's a song in Hamilton called "The World Turned Upside Down." And whatever else is true, the world is turned upside down. Let me actually go off script here and tell an embarrassing story. So I'm in the fortunate position of occasionally getting to speak to large groups, especially in print. And so I wrote an op-ed. And I wrote an op-ed that was posted, strategically, by the way, posted. I'm very savvy at these things, except for when it goes absolutely spectacularly wrong. So it was posted at something like 7:45 when the election results were coming in. And the point of this op-ed, the op-ed's title was, oh gosh, I don't even remember my own title. But anyway, the point of the op-ed, the title was something like, "It is Clinton supporters that should be mad and disappointed tonight." Now, I rush to remind you when this was strategically posted, right? It was meant to be posted to point out that even though Hillary Clinton had won the election, I told you I'm very savvy. Even though Hillary Clinton had won the election, the fact that Donald Trump had come so perilously close to winning the presidency, the fact that America had decided to turn a blind eye to a campaign that was motivated and premised on, indeed, the fact that Donald Trump's political birth was entirely premised on his trying to undermine the very legitimacy of an African-American president as an African-American was so painful that we would have to work very hard to repair our civic bonds going forward. That was my view when I thought Hillary Clinton was going to win. So, nonetheless, I promised Francois that I would give this talk rather than my first two options, which was, one, to rant for an hour. I've been told that's unprofessional. My second was to gather you all in for a therapy session mostly focused on me. I was told that was selfish. So instead, I'm going to try awfully hard to focus on giving you a story that's plausible and instructive, though it will take, I tell you this because I must admit it'll take some energy to stop from occasionally lashing out. And if I do, I only ask that you pardon me. It's only been a week and a half. I'm working on it. Okay. The story is, these things are so hard to forget because we human beings only live some 60, 70, 80, 90 years. But in fact, time goes very, very fast. So if you're interested, you should know that modern policing is brand spanking new, right? The early modern police forces started at roughly around 1820s, late 1820s, 1830s. These things are always controversial, it's hard to find. And of course, they're historical analogs for time in memoriam of the way in which we police. But the idea of a professionalized, permanent, modern police force is actually fairly new. We're talking, under 200 years old. That means, by the way, that, if you're old now, you have grandparents that knew no police, no real police, right? I could talk endlessly about the history of police. I'm actually not an expert in this, but I spend lots of time studying it to inform my philosophy. And it is fascinating to remember that once upon a time, there's an old saying, a hue to cry or call, or et cetera, et cetera. This is what it meant to call for police. This is what it was to galvanize citizens to police, because there was no modern police force. In America, fundamentally, the modern police force was tied to the end of slavery. Right? So the immediate precursor of the modern police force were the slave patrols and night watches. Right? Now, night watches in some places existed even without slaves, but their largest reason for being was in order to control, search, and punish runaway slaves. That was the immediate precursor in America of our police. Now, look, it'd be silly to pretend that police is a uniquely American institution. Of course, there are police everywhere, even in places where slavery ended more peacefully, like Great Britain, and indeed all around the world. As countries and cities started to modernize, police seemed to become a modern necessity. By the way, even in ancient times, the tension between class control and just policing existed. So for those of you who want to know how exciting my life is, I sometimes spend time reading about policing in ancient Athens. The remarkable thing about, by the way, page-turning stuff, I assure you, right? The remarkable thing about policing in ancient Athens is if you change some of the language, I mean translated language, right? And you change the names, you could plop some of these conversations on the front page of the New York Times. And there's this great roiling conversation about the way in which the police are unnecessarily violent at the harbor in Athens. But after all, what are we going to do? These barbarians have come in from a different land, they speak a different language. And so the idea that police have always existed in part to control both unruly, dangerous people, and the intersection with that and unjust class policing is nothing new. What is true is that in America that had a very particular image, a very particular institutionalization, because it was infused with the American experience with slavery. So from ancient Athens to Victorian England, we start to modernize the police. Now, for us in America, that's an odd feature. And again, let me remind you of why there is no race in policing in America. Some of you may know that in America, our federal, our highest policing statute, so to speak, it's hard to translate these things, but you know what I mean, is the Fourth Amendment. Right? The Fourth Amendment to the Constitution is what governs police. Now, I want to be clear about this. It's a little bit equivocal because policing in America, in fact, is the quintessential state power. Right? When we talk about state powers, we often call them the police powers. Right? So indeed, and at the moment, from my point of view, quite blessedly, policing is largely in the hands of the state. And by the way, let me say, for an African American, given our history, to think that policing being in the hands of the state is a blessing tells you where we are federally since last week, for no reason in particular. Okay. The Fourth Amendment, for those of you who don't know, and perhaps there's no reason for you to know, was actually written in response to English domination of American policing, in particular to the general warrant. There's some controversy about this among Fourth Amendment historians. There's a big debate about what the warrant clause means versus what the reasonableness clause means. That's not important for our purposes. What's important for you to know is that the Fourth Amendment prohibits search or seizure unless on probable cause, right, pursuant to a warrant, unless it's reasonable. Okay, I'm stopping here for a moment because there's a deep debate, internecine debate among scholars who care about these things, about the relationship between the warrant clause and the reasonableness clause. That's not important for our purposes. Here's what's important. It's always been the case that notwithstanding that the Fourth Amendment governs search and seizure, there have been exceptions to the warrant clause and the way it affects arrest. Which is to say, obviously, if a police officer stumbles across you committing a crime, they're not going to go get a warrant, right? So there's a whole world of policing which has always been subject to police seizing people pursuant to probable cause, even when they can't get a warrant. And that was the way it was in the United States for many, many years until 1968. Now, there's no reason for you to know this, but in 1968, the United States had what we've come to call the Warren Court. The Warren Court's a remarkable court. It'll go down in American history. It's gone down in American history because of its particular focus on the relationship between minority rights and state power. Indeed, the Warren Court was so dedicated to the cause of minority rights being enshrined and protected in the Constitution that it became one of the issues in Richard Nixon's first election when he accused those distant people in robes of not backing up our police and setting criminals free on your streets, right? This was the liberal Warren Court. So there's something deeply ironic about the fact that it was the Warren Court that was presented with a case that changed the nature of American policing. That case is called Terry v. Ohio, 1968. Now, remember I just told you that police could not stop or seize somebody unless they had probable cause. In Terry, and I'll try to tell the facts briefly, in Terry you have a police officer, his name was Officer McFadden, older gentleman, he'd been a police officer for a long time. And he's in downtown Cleveland. And Officer McFadden sees two men, and they're behaving oddly. These two men, one of them will go, he walks up to a store window, he looks in the window, and then he walks back, and he chats with his colleague. The colleague then goes, looks at the store window, comes back and chats with his colleague. And by Officer McFadden's reckoning, they did this something between 6 and 13 times. They just kept doing this over and over. So McFadden notices them, and he decides that they're probably casing the joint. Right? They're casing the joint in order to knock it over, so to speak, to rob it. Right? And he thinks because it's going to be a daytime robbery that they're probably armed. So when these two people walk away, and they meet another gentleman, the three of them start speaking, Officer McFadden either boldly or bravely or brazenly, depending on your point of view, approaches them and says, "I'm a police officer. Who are you? What's your name?" And they mutter something back, and Officer McFadden is unsatisfied with whatever it is they say back. And as a result, he grabs one of these men, spins him around, slams him against the wall, and pats him down. And he finds a gun. He does the same to the other, and again disarms him, right, and pats down the third. Right. The question, of course, is, did Officer McFadden, the question for the constitutional laws, did Officer McFadden seize these people? And if he did he have probable cause to do so? By the way, one of the odd things about this case is, again, notice we have seen nothing about race in this case. I want to keep reminding you, lest you think I'm cynical, that race has played no role in anything I've said so far. Maybe a little bit with slavery, a touch. But otherwise, we've seen race nowhere in these cases, right? I want you to think about what's just happened. Officer McFadden, in some ways, has shown an extraordinary amount of bravery, after all. He single-handedly approached three people who he thinks may be armed. In another way, Officer McFadden has also walked up to three people he doesn't know without probable cause, and when unhappy with what they're saying, accosted them. And the court had to decide what to do about this case. Right? The court says, look, Officer McFadden is dealing with a different situation than an arrest. He's dealing with a stop. And a stop is different because it's a temporary seizure. Now, the court actually does know that a stop and search of this kind can be an important seizure, and it can be a humiliating moment. Indeed, the court, I will say to its credit, actually drops a footnote about the way in which you're supposed to frisk somebody, including feeling them around their upper body, in their armpits, and in their groin. And the court is very clear that this can be a moment of extraordinary domination and humiliation. So they say, we're going to say this is governed by the Fourth Amendment. This is no small thing, by the way. There were people who, when Terry came up, were afraid the court would find no search at all, right? So that the worst thing that could happen at least hadn't happened. But then the court says a couple interesting things. It says, look, even if this is a search, it's not the same sort of full search that's governed by probable cause. This is a different kind of thing. This is a stop and frisk. This is where Americans learned the phrase stop and frisk. And a stop and frisk can be conducted on the basis of reasonable suspicion, a lower standard than probable cause. Reasonable suspicion that the person is armed, so long as an officer has articulable suspicion that a person is armed, right? By now, some of you are getting irritated that we haven't noticed anything about race. Let me point out that the court did not notice anything about race. Nowhere in the opinion did the court mention the race of any of the parties involved. So some of you will not be surprised to know that the two men who were looking in the window were African American. Officer McFadden was not. And indeed, one of the things about Officer McFadden is, to his credit, he's at least, as is described by scholars who got to know him later, a straight-spoken, plain-spoken man, right? So when they ask Officer McFadden, how did you notice these two? Why did they attract your attention? He says, they didn't look right. They looked out of place. I didn't like something about them, right? Officer McFadden is not one of these people who's going to at least pretend that it was an accident he noticed. Nope, they didn't look right. They looked out of place in downtown Cleveland to me, right? But the court doesn't mention ever the racial identities of any of the people any of the people involved. What the court does say is, it does mention briefly race. It says, look, we'd be less than honest if we didn't admit that this case brings up sensitive issues that we have not touched on before. In particular, the widespread harassment of certain communities, particularly the Negro communities, of which we've heard complaint. Then the court says something very interesting. It goes on to have a rather fatalistic pronouncement. It says, even if that's true, police officers are so motivated to make sure people aren't armed that there's nothing we could do about it. It's actually a remarkable moment for a Supreme Court in a decision to say, what can we do anyway, right? So the Supreme Court gives Americans essentially their first taste of stop and frisk based on reasonable suspicion. Okay, forgive me, what time? I meant to time myself. 15 minutes. I'm gonna skip some of the case law because it goes on and on like this, but here's the point I wanna make. The court's infusion of the ability of police to conduct stop and frisk without ever noticing the race of the people involved set the course for American criminal law for generations to come. So in America, when we talk about police violence, the way in which we talk about police shooting somebody is to say they've been seized. It's a very odd thing that this is the antiseptic language we have. If the police shoot and kill you, they've seized you. And the only question is, did they improperly seize you? So in Tennessee v. Gardner, which is not the Gardner you know, who was choked to death, it's yet another Gardner who was killed many years ago in Memphis. 2 police officers shot a fleeing felon, which was legal by Tennessee law at the time. He was suspected of a burglary. They saw the young man. They knew he wasn't armed. They shot and killed him. Right? And indeed, they did find the purse that was stolen. It had something like $6 in it. And for this, young Mr. Gardner died. And there the Supreme Court said, shooting a fleeing felon unless they're a danger to somebody is an unlawful seizure. It's excessive force. Something for you to remember as you're seeing the slew of American cases now. Yet again, though, the court never mentions the race of the people involved. In that case, by the way, it was quite complicated because the Memphis police officer that shot Mr. Gardner was himself one of the few black officers on the Memphis police force. And there was incredible conversation about the fact that the black officers on the police force felt the need to be even more machismo, even more violent in order to prove themselves to their white officers. And indeed, there were amici briefs that showed that police officers were twice as likely to shoot at black felons for the same crimes as white felons. The court noticed none of this, right? The cases go on and on like this. I'm gonna skip ahead through some of the cases. I will tell you that one of the few places where the Supreme Court has mentioned race in American law was, not surprisingly, in the border cases where race is somewhat unavoidable. So the Supreme Court has determined that visual evidence of ethnic identity can be a factor in stopping people, but not by itself decisive. Okay, all of this zooms ahead through case after case, with the court steadfastly ignoring the way in which race plays a role in policing, no matter the evidence, until we get to a case called Wren v. United States. In Wren v. United States, to put it very simply, the police stop somebody because they want to stop him, right? They see a car in what they call a high crime area, they want to stop the car, so they wait for the car drives off, the police officer says it was driving at an unreasonable rate of speed and pulls them over. When they pull them over, they find the passenger, who is just sitting with bags of cocaine in his hand. There's just a lot of odd things going on there, including if the police pull you over, you might want to put down the cocaine. But nonetheless, the important thing for our purposes is the question of whether or not when the police, I should just note one more thing. The police officers that stopped them were undercover police officers. They were not traffic officers. So there's just no question that it was a pretextual stop, right? So the question the court has to address is, are police permitted to stop somebody on a pretext? And the Supreme Court rules, and let me point this out again, unanimously. The Supreme Court rules unanimously that an officer's motivation plays no role in the reasonableness of a Fourth Amendment stop. Let me say that again. An officer's motivation plays no role in the legitimacy of a Fourth Amendment stop. The court does drop, I think, if I counted correctly, I think it's 3 lines that says something like, of course it's true that if you can prove that you only came to police attention due to your race, then you could file a suit. But that's not a matter for Fourth Amendment law. That's a matter for 14th Amendment law. That's the sum total of the discussion of race in Wren. And by the way, the court does so without ever referencing that its own jurisprudence has made 14th Amendment law almost intractable. Now, this case can be contrasted with another case called Delaware v. Preuss. Delaware v. Preuss isn't important to you except for to say, Delaware v. Preuss is a case where the police were just pulling people over to check for driver's licenses. And there the court said, you can't do that. You can't just stop somebody without any probable cause, right? Which is to say, when we talk about stopping people generally, we have made the decision that even if it helped fight crime, we don't want to live in a society where the police can simply pull people aside for no reason. But if the police can layer a pretext on there, then it turns out that it's immune from legal inspection, right? That it's immune from legal inspection. By the way, for those of you who are interested, and I say this quite literally, I live in New York, so sometimes when I teach my students this, they don't quite get it, right? Because in New York, we are happily a walking city. But I come from the Midwest. And in the Midwest, your car just is life. It's just the way you move, right? And for those of you who have a driver's license, you should know, and I mean this without exaggeration, it is impossible to drive legally. You can drive reasonably, but you just cannot drive legally. The legal codes governing driving are so thick that if a police officer wants to pull you over, they need only follow you for a few minutes and you will break the law, because it is quite impossible to not break one of the driving laws is one must drive paying reasonable and sufficient, or something like reasonable and superlative attention to the roads at all time, right? And it's for an officer to decide if you're not doing that, right? So allowing a pretext to insulate police ability to pull you over is to allow police to police an entire group of people as they wish. By the way, on top of all that, there's a small, rather boring case that a few people notice called Devenpeck. Devenpeck is a neat little case because in the case, a police officer pulls a guy over because he thinks he's impersonating a police officer. He was. But while he's doing that, another police officer comes and they see he's recording them. So they arrest him for recording him, right? Turns out recording a police officer is not illegal in the state, right? I think it was Washington. So it's not illegal. The court has to deal with the fact that this man has now been arrested based on probable cause for a crime that is not a crime. And the court says something interesting. It says, well, okay, he didn't commit the crime you thought he committed, but you did have probable cause to believe he committed another crime. And that will be sufficient to ground the crime. I want you to understand what Devenpeck and Wren mean when taken together. If you read these two cases together, what it means is that not only can a police officer just make up a reason to pull you over and insulate their decision to pull you over from judicial inspection, but so long as a police officer can eventually recall a reason they pulled you over, they can insulate their pulling you over from judicial inspection. That's where American constitutional law has left us, right? Now, there are a few more cases about which I would love to speak, but let me flip ahead to actually a case that just came down this summer. In this summer, there's a case called Utah v. Strieff. Now, I want you guys to think back, because some of you may have forgotten all the way back to this summer. This summer, politics was on the mind of Americans. You may have heard. Right? Not only were we in the middle of a vicious presidential campaign, but we were at the height of the most important and sustained conversation we have had about race and policing in generations, at least since the Rodney King beating. In Strieff, a man walks out of a home he's suspected of buying drugs. The police officer pulls him aside without probable cause, right? He only thinks he's buying drugs and essentially arrests him. Right. Again, this is now unconstitutional. In doing so, he then runs the man's name for a warrant. And it turns out that Streiff has an outstanding warrant. And thus the police officer arrests him and finds contraband on him. This case makes it all the way up to the Supreme Court. And the Supreme Court, on the pen of Justice Thomas, rules that because Streiff had an outstanding warrant, the fact that the police officer stopped him without probable cause is insulated from constitutional inspection. It is reasonable by the Fourth Amendment. And again, Justice Thomas, no less, says this without ever asking any questions about the way this might impact differentially between race and class. It's only Justice Sotomayor in dissent who says, and let me say again, at the height of the Black Lives Matter movement, no matter what you think about this case, the fact that you can make this ruling without even mentioning race is shocking, utterly shocking. Right? It's only Justice Sotomayor who says this is not a case about technicality. This is a case about policing different communities differently. In case you think I'm being overblown or melodramatic, you should know that in America, there are literally millions and millions of warrants that are outstanding. And these warrants are highly concentrated in poor communities and communities of color. In New Orleans, beautiful New Orleans, last year there were 20,000 arrests pursuant to outstanding warrants, minor warrants, right? Parking tickets, unpaid child care, right? Things that we might care about, right? Look, I care if you pay your child support. It's important. It's a moral duty. But to imagine that not paying your child support means that now you are governed under an entirely different set of rules about how you can be policed is striking. When I say there were 20,000 arrests in New Orleans, you should know that that was 1 out of every 3 arrests in New Orleans was subject to an outstanding warrant. In the city of Ferguson, which has now scarred itself into our national psyche, Ferguson was a city of 21,000 people, of which 16,000 of them had an outstanding warrant. 3 out of every 4 people in that poor African-American community had some sort of outstanding warrant. By the way, some of this is not surprising because it turns out that once one bad thing happens to you, more bad things start happening to you, right? So you get a fine, you can't pay the fine, then an outstanding warrant goes out for your fine, right? Then you have to pay for that outstanding warrant. Now you can't pay for the fine and yet another one, right? And I don't say this just because I want to exaggerate. I recommend to you the DOJ report, which shows how Ferguson's police force essentially just became a rental collection agency for the city. How explicitly the city's mayors and officials would just tell the police, we need more tickets out of this community in order to keep the city coffers going, right? Again, the story I'm telling you here is a story about how our laws have allowed essentially 2 different policing forces, right? One for middle-class people, often white people, but especially wealthy people, whatever your color is, that can push back against police inspection and live under the kind of society that we claimed in cases like Delaware, a society that says it is impossible and oppressive for the police to be able to stop me whenever they wish. Another is for groups of people who can be stopped at will on the roads or in the streets because of their race and class. The effects of this are exactly what you imagine. In study after study, African Americans and Hispanics and others are policed vastly differently, right? So the ACLU did a study. I think there was one in Virginia and one in Florida, right? The one I remember was, I think the Virginia one, in which 17% of drivers on the road were African Americans, but 80% of the people pulled over were African Americans. African Americans, by the way, the ACLU also tried to code for traffic violations, and you won't be surprised to know there was no difference. There's no evidence that being black makes you a worse driver. So you can rest assured, right? So there seems to be something else going on there as to why the police were vastly more likely to pull over African Americans, subjected them to searches twice as often, and stop them for twice as long. And by the way, just to twist the knife, were no more likely to find contraband on African Americans that they pulled over. Indeed, were slightly less likely to find contraband on African Americans they pulled over. That actually doesn't surprise me because actually I suspect if you're actually waiting for people to be suspicious to pull them over, you'll have a good hit rate. Whereas if you're just pulling over every dark person you see, right, your hit rate is just going to track however many people in that population have drugs, right? So that's actually probably sensible, right? Why that turns out that way, right? Again, what we see is a story where the Supreme Court refuses to see race in the ways in which our laws govern different people. Now, I believe I should wrap up. So let me just say a couple things. So my job is typically to be a philosopher, which is a sometimes frustratingly decorative job. So it's hard to know exactly what to do about this. I have pointed out in various publications that we're at the point where it seems to me that taking on the doctrine is not sufficient. It seems to me that unless we're willing to take on, in some serious way, the underlying thinking behind these doctrines, the idea that all that matters is whether or not you violated some law, no matter what it is, right? Be it a driving law, right? Some nominal law that we can get to, or some warrant that's outstanding, that's sufficient to pull you over, to stop you, to frisk you, is to fundamentally mistake the way in which police and citizens are related. Put simply, the ways in which we're bonded, the ways in which we can be a community, turn entirely on feeling ourselves to be equal members of the community. And we shouldn't take that for granted. I read somewhere lately, somebody said about the Trump election, you Americans treat your democracy like it's a football. It's not, it's a Fabergé egg. And there's some real truth to this. People misunderstand how delicate our civic bonds are. They misunderstand what it's like to be in the gaze of police, contempt all the time. Look, my life is very luxurious. I'm a very lucky man. I'm a law professor. I live downtown New York. Life is fairly good. I cannot tell you, even for somebody as insulated as I am, the utter rage you feel when a police officer pulls next to you, looks into your car, and then drops back again to pull you over, and knowing why they're doing so. It is to feel yourself not just made a second-class citizen, but to push back against the bonds that make it the case that you ought to obey the law. These bonds are also under threat when we systematically ignore the way in which the law allows us to insulate these offenses. So one of the things I worry about the most has been the sudden discovery of the ways in which police violence affects minority communities. So again, if you're historically minded, you can go back and read from W. Du Bois through James Baldwin to Ta-Nehisi Coates last week. The unending complaints of African Americans and other minorities in the ways in which police violence is visited upon them. Not just police violence, but allow me to just say a couple more things, but policing generally is visited upon you. So one of the things that's true for African Americans is that we have come to realize that there's a certain lack of humanity between our country and ourselves. And let me put this quite plainly. When problems afflict the white community, they are seen as social problems. When they afflict the black community, they are seen as police problems. Right? Let me give you just one example. As some of you know, 30 years ago, America was going through an extraordinary, painful, and deadly epidemic of crime, and in particular, drug addiction. The crack cocaine epidemic swept through American cities and was utterly devastating to huge communities, in particularly black communities and communities of color. America responded by discussing the pathology of the black community, broken homes, the lack of fathers, and responded with utter policing terror. The idea was to set up a line and make sure at all costs that those things did not reach our good neighborhoods. And after years of this, when crime had metastasized into gang violence, as it always does, if you allow this sort of thing to happen. By the way, let me repeat, as it always does, prohibition reminds us that there is no monopoly on the fact that if you allow people to pursue huge amounts of money in a black market. Violence will follow. Right? That was the American response to the crack cocaine epidemic. America now is going through a very similar epidemic. Heroin and opioid use has started gutting communities, in particular rural and white communities. For the first time in a generation, and this is a stunning fact, white Americans have had a rise in mortality. Lifespans have decreased. In the wealthiest country in the world, the inexorable march of history upwards has stalled. And the reason has largely been suicide and drug use. The response to this has been remarkably different. So, I had the out-of-body experience of watching Republican presidential candidates stand up on stage and speak movingly about how their children, brothers, brother-in-laws, stepbrothers had all been struck by drug addiction, and how we as a community had to do something about this, right? How we couldn't leave these citizens behind. Police chief after police chief has said, we are not going to treat this opioid addiction like these aren't people. These are real people with real souls. They have lives to live. I remember reading a narcotics officer quoted as saying, these are real souls, and I just don't know why I didn't see that before. Police chiefs say, we're going to be here for you again and again and again until you recover. We're told to take people directly to rehab. Kroger's, which is a store in the Midwest of America, has started carrying overdose serums, naloxone, right, for free in the store, telling people, if you need it, you come, we will help you. I dare anybody here to imagine Kroger's in 1985 saying, if you are doing crack and you need help, come here, we will help you. Right? And let me just point one other thing out. This is not just true about drug use, because that sometimes obscures the truth. Heroin addicts steal their mother's purses. Heroin addicts get in fights with their brothers. Right? Heroin addicts get in fights with each other. Even things that are uncontroversially violent, a beating, a fight, a robbery, a theft. There's a social choice in how to treat these things. Right? The social choice we've made for this generation, when drugs are affecting a white community, is to say this is a social problem. And our first and foremost job is to repair these communities. The choice we made, right, so just to finish that up, so police chiefs have told their police officers, remember, when you run into somebody who's gotten into a minor fight that we can avoid prosecuting as a beating, you ought to remember that this fight is a symptom of their drug abuse, not a crime. This was not the response when African Americans were afflicted with the exact same kinds of problems. This is true over and over and over in American life, right? When African American schools are in trouble, we send police. When white schools are in trouble, we send counselors, right? And on and on and on. This presidential election had a remarkable split where we're now discussing the way in which an entire community, rural communities of working class white people have been left behind, and how we must make structural changes because of the way globalization has hurt this community. But if you change that conversation to the way in which we must make structural changes to help minority communities, you will be called a race baiter. I know this because I sometimes say these things, and I am called a race baiter. Right? So we have this way in which in America we've become dedicated to not seeing race, and in particular dedicated to not seeing it in our criminal law. And thus I say to you that the only way we can make this change, in particular I make the suggestion that at some point we simply must make whether or not a police officer's actions are racially motivated part of the Fourth Amendment reasonableness clause. We could stand up as a community and say, whether or not the police officer is racist isn't just a question of equality, it's a question of reasonableness. It is unreasonable to treat your fellow citizens this way. But I say to you, and I'll just conclude by saying this, it's a Fabergé egg. It's stops like this over and over and over that have led to the spectacular incidents you've seen. It's Walter Scott being stopped for a broken taillight, who is then terrified because he has outstanding warrants for not paying child support, who gets out and runs, that precipitates an incident where now a police officer quite cruelly just shoots him down like it's sport. It's Philip Castillo being stopped again and again and again. Sandra Bland stopped for a traffic violation. And one of the problems we have is that now that there's a group of Americans who are shocked by this, there's a Black community that is shocked that they are shocked. That is to say, if a community has spent generations telling you that something's the case and you have refused to believe them, there's actually a sad, almost cruel moment when you say, has this been happening? How would we have known? I just give to you the cheap analogy. If you were dating somebody and they told you over and over and over that somebody was treating them dishonestly, cruelly, that their boss was harassing them, and then you go to the Christmas party and you see their boss harassing them, and you said, well, honey, how odd, I never knew. Your relationship would not last. You would break up because the inability to care and trust somebody enough to take their words seriously will eventually erode your civic bonds. And so I just want to close by saying saying these things does not make me happy. It doesn't make me feel particularly empowered. I don't get a toaster. I say these things because I'm deeply concerned. I think the fraying of our civic bonds, in particular our racial civic bonds, is real. I think it's not a surprise that there are Black communities that feel like the police are an occupying force. It's not a surprise that our lives have grown increasingly distant and people don't even know how to speak to each other. And part of that, as reflected in our inability, even in our law, to see the way in which race affects policing, is that we're willfully blind to the way in which the law has insulated this. So that's my story to you about how, in fact, despite everything you might think, it turns out that there is no race in American policing.
So thank you very much, Ekow, for these quite sobering thoughts, so eloquently put. So we have about half an hour for questions. I urge you to seize the opportunity. There are 2 microphones. And so don't feel shy. I guess I could start us off. Once somebody has the realization that you've exposed today quite blatantly, how can you then reconcile that with being a law professor and teaching this stuff?
Yeah.
And how should people in the classroom who are learning this stuff think about what they're doing?
The first one is a tough one, and it is the kind of thing that sometimes deeply worries you. I mean, bad enough that I'm a law professor, that I'm paid to be a philosopher is even more obnoxious, because you feel so distant from the problems you have. The one thing you hope is that when you teach, you can at least offer people some insight into the way these things happen. That is to say, I do get tired of conversations that are so purposely and willfully blind. Look, I think there's serious disagreements in how we should police. There's serious disagreements in what counts as justice. There's serious disagreements in how we should go about it. But what's true is that there's a certain laziness in even trying to seek these problems, right? So you have a presidential candidate. Let's just really quickly, we have a presidential candidate who stood up and said, what I believe in is law and order. Law and order in America is a very particular phrase that was used generation after generation to imply domination of urban communities, Black communities in particular. So the fact that President-elect Trump, God help us, can use these phrases without anybody calling, or without enough of the population calling him on it, that's where you do feel like teaching this stuff matters. The fact that he stood up and said, look, Rudy Giuliani, my close friend and advisor, I lived through the Giuliani era in New York. It is not something I'm in any rush to get back to. This is what Rudy Giuliani used stop and frisk, and it was hugely successful, and thus we should use it again. So the question is, how do I teach? Look, here's the thing. Think how obnoxious it would be in any other realm in our political lives to say, this really bad thing is happening. Your community is injured in this way. I think the answer is more oppressive, violent policing, even though you keep telling me that's not what you want, right? I mean, it's just this remarkable obnoxiousness, as though there's this haughty sort of, no, we're gonna help you. We're gonna send in more police. Even though you have minority communities saying, we keep telling you that's not what we want, right? Or when we want more police, we want them in conjunction with these million other things that matter. Indeed, we want them in the same way that you want them when your communities are injured. And so you hope that those things matter. You hope that, lastly, teaching that these conversations are sometimes just plainly false matters, right? So people talk about the crime rate drop in New York during stop and frisk, but nobody ever mentions, by the way, that the crime rate dropped equally or more in cities all across the country, all of whom used different tactics, right? So Boston used a very different tactic of community policing, and its crime rate dropped just as much. The real truth is, for a generation, for reasons that criminologists are utterly puzzled by, crime plummeted. And it plummeted no matter what you did, right? So at least if I can teach people those facts, we can have serious disagreements and goodwill rather than these willful, blind invocations.
Anyone else? I'd urge you to come to the microphone just so that we hear what you say.
I can project.
There's also recording, so we'd prefer if you use the microphone. Thank you.
You have to take your star turn. Take your time.
I'm a little short. Okay, so, I thank you for that lecture. And in the best way possible, I have to say it made me incredibly angry. I was sitting there shaking. And one of the reasons is we live in Toronto in Canada. It's very different. The climate here is really different in terms of race relations and policing than in the States, for sure. And what I hear a lot as a colored person is, you're imagining this. And a lot of what we see in the media too is Canada's not like that. Canada's not like the States. And why your lecture enraged me so much is because the same concerns that I have, looking at our news, even last night we're tackling opioid addiction here as well. And all the pictures that are shown of who's affected by this, they're homogenous pictures of the communities, rural communities in BC and Alberta that are affected by this. And I come from a Caribbean family too, and when we see those things, we say, this has been a problem for a long time, and now that it's affecting white people, now we're finally talking about it. And even in my head, I thought, God, my parents are crazy. Why are they, why do they see these things? And hearing your lecture really opened up my mind to the fact that it's not just in my head. And that's sobering and that's enraging. And I thank you, I guess, for that. But one of the things I want to ask, and I don't know if I 100% support the way that certain movements like Black Lives Matter are going about addressing this issue, because to a point it's extremist, and some of the things that are being said incite more rage and create more division. And some of the things that people do in the name of Black Lives Matter, like maybe shooting other police officers, although not sanctioned by the group, but done in the name of that group, I don't agree with. And I want to know what we can do. And you're preaching to the choir here. Like, we're all in law school to make a difference. You're a law professor teaching to law students who want to make a difference. But on an individual level, on a policy level, what can we do to address these things? I mean, the Fourth Amendment, those rules were laid down by SCOTUS. I mean, how do we fight that? It's the highest law, the highest court in the country just laid that down. And how do you bring that back up? And how do you on a personal level and on a policy level fight that?
So first of all, let me say it is not all in your head. Though I'm really sympathetic to what you mean by that. I do think one of the sad things in race conversation is that white people and Black people have such different views of what it's like to be Black. So you have so many white friends, even people I think are very, very decent people, who think Black people see race everywhere, right? Or make it up everywhere. And I don't know about you, but my experience, and indeed, I think the experience many Black people, when we talk, it's actually worse than that. It's that you really rarely know what's happening, right? Which is to say, one of the really awful things about living in a place that often dings you because you're a person of color is that you don't know why you're being dinged, right? So they're, you know, I'm letting people in on secrets, right? Everybody, look, I mean, it's really unsettling to be uncertain about what just happened, right? So did this person dismiss me because they're having a bad day, or did this person dismiss me because I'm Black, right? And carrying that around causes all sorts of anxiety. Right? So I find it odd that so many people are in a rush to dismiss Black uncertainty as though the big problem is that Blacks are certain there's racism everywhere. When indeed, you know, you hear, oh, you're playing the race card. And I always want to say, if you knew how often most Black people stop themselves from thinking what this might have been like, you would have, you know, you have no idea the everyday uncertainty that includes. And it's especially true, by the way, that this uncertainty is not bizarre, because then they'll do, you know, whenever anybody does anything like a scientifically controlled study, the results show exactly what you worried about. So I'm very sympathetic to the way in which sometimes we have to gird ourselves with strength. Okay, what can we do about it? That's a tougher question. I mean, so usually I'm more optimistic. You know, I've had a tough 10 days or so my optimism is struggling. But usually my advice to students is, look, you guys are in an incredibly powerful position, all of you, right? And I'm not speaking to just the students of color. You are all in remarkable positions, right? You are in a position to insist that the law treat people not just with a minimally just law is already terrific, but you can also insist that the law treat people with decency, right? And decency is more than justice. So it's the case that you can choose whatever it is that you care about and do well, and really do something there. And I know this doesn't sound sufficiently radical. That's probably a failing of mine. But I think radicalism has to be really combined with serious purpose, right? And that for a law student means picking usually a project or two that means a lot to them and working hard at it. Because I think often people wonder, well, you know, how come that guy's the head of this agency and he gets to, but he wasn't born the head of that agency, right? He picked something way back here and worked his way up, right? So I think picking things you care about, I think getting involved in your community boards, I think running for office or working in a political office when you can matters, right? I think and lastly, I think sitting down and speaking to people, arming yourself with some facts helps. I know it's not a cure-all, but you know, telling people, look, there's no evidence that stop and frisk reduces crime, and telling them in a way that is serious and backed up by information, at least helps puncture cheap conversation, right? And those are the things I do to contribute. God knows it's not a lot. The last thing I'll say on that, so one of the great honors of my career is I was cited in the ruling that struck down the stop and frisk program in New York, found it unconstitutional by Judge Shenlin. And obviously my being cited was a very, very small thing. By the way, I'll tell you another embarrassing secret. I was cited immediately after the President of the United States, which is awesome, except that the President of the United States was cited as the President of the United States has said, ... as another commentator has said in that section. So I've worked my way up to being another commentator. I hope one day to be some guy. Anyway, look, but here's the deal with the stop and frisk ruling, Floyd it's called. Stop and frisk was struck down in New York because the president said something. It was struck down because the New York Times ran a relentless campaign exposing how it was entirely inefficient and racially biased. It stopped because people were marching in the streets. It stopped because lawyers litigated this case as a class action. It stopped because Jeffrey Fagan, who's an expert on these things, was the one who gathered all the information. Who's also quite fortunate. He was once upon a time my professor, now my friend, right? It's just to say, it just takes a huge army of people to get any big change. And if all I did was chip in one thing that helped, you know, mine was incredibly small compared to what everybody else did, but hey, everyone else just did their bit, right? And I think those things turn out to matter.
Thank you.
Bring the mic over.
Okay.
I see we have one more ahead of you.
Thank you so much for bringing the only thing resembling a constructive conversation to a time that otherwise feels like no constructive conversation can be had. And it's not in your head. Canada is no better off structurally than the United States is. And I just don't know how we can come to a point where that is an explicit conversation that we can have, because until we can, I don't think that we can move it forward in any way. And unfortunately, your analogy of a dating relationship limps a little bit, because it's more like a family or an attached set of apartments, and so it's very difficult to just walk out on it. But I wondered whether a lens through which it would be worth looking at from a legal scholar's perspective. The law really hates arbitrariness. It hates the idea of arbitrariness. And in general terms, everything is objective or it's reasonable, and it has to rise to that standard. And I think that in the creation of laws and in the application of laws, oftentimes reasonableness and objectivity are as closely followed as that pretense makes it possible to do. But I wonder whether it would be useful to think of arbitrariness as on the side of application and also as on the side of implication. And so it's maybe not arbitrary what is being put together, but it is arbitrary how it is implemented and therefore received. And what I mean by that is exactly what you said about the uncertainty earlier. As a white woman living downtown in a middle-class house, I can rest assured that no matter how much I yell at my kids, nobody is going to call anybody on me. But if I were a person of color, if I were in an apartment, if I were an Indigenous woman, I wouldn't know which time somebody would call me out for that and which time I would be in peril having my children taken away. But I could pretty much rest assured that that might happen, and that is nothing but arbitrariness. And I wonder whether that would, because the law sees that as such a powerful construct, whether that would be a useful tool for starting that conversation structurally.
So first of all, thank you for the question. I want to say, on the one hand, I do totally agree with you that analogies can fail by what they obscure as well as what they show. But the one way in which I want to defend my analogy, not as a personal matter, but just as a worry, is that I sometimes think we underestimate whether or not we can walk away. I mean, I do think, look, there are countries that have gotten to the point where there are communities that are entirely disconnected from each other, where the ways in which the communities relate to each other is just catch as catch can, get over, take what you can get and go, right? If the police catch you, so be it. That is a dangerous place to live, right? So those of us, so I grew up in Ghana, West Africa. Luckily when I was there as a child, the coup we had was peaceful, but I lived through a coup as a child, right? I know countries where the bonds have so frayed. You can be in a cab and talk to somebody and there's just a deadness in their eyes because they're so defeated by corruption and police. So sometimes, though you're absolutely right, it's meant to be a glib or sometimes it's meant to be a slightly charming analogy, but I don't want to lose that. People do walk away from their civic systems. They really do. And it is, if you've ever lived through it, those of you who have visited kleptocracies, you know what that looks like. And to borrow Sinclair's line, it can happen here. As to your point about arbitrariness, I agree with you. And I think that is a tremendous and strong way to attack it as a lawyer. I think it's the way in which the law speaks. And in that way, part of what lawyers do is take the way in which the law speaks and use it for good. My worry is that, Learned Hand was swearing in a bunch of citizens during the Second World War at the same time that Japanese citizens were being interred. And they asked him, what can we do about the Constitution? What laws can we pass? And he said, at the end of the day, there are no laws that will protect the Constitution. It comes down to the people. If people don't care to fight for their Constitution, it won't matter. So, and the reason I bring that up is it seems to me there are lots of things we can agree on in paper, right? All of us will agree that somebody who beats somebody else should at least be open to police intervention. But how we apply that seems vastly different, even on non-controversial grounds, for controversial reasons, right? So, you know, the two brothers who got in a tiff, we just say they got in a tiff. But if they're two young black boys, or if, then well, he's a thug, right? So I agree with you that the arbitrariness will matter. I don't see how the law, without us being deeply committed to upholding it personally, can change that anymore. Maybe I'm suffering from after an election like we just had, it's harder for me to see. I now see more clearly how institutions cannot survive without the beating heart of the people behind them, in a way that maybe I needed to be reminded.
Thank you.
Thank you.
So my question kind of comes from my own experiences as a person of color and my own continuous struggle with internalized racism and the internalized racism that I see amongst my fellow friends, as well as our interracial kind of discrimination and prejudices towards one another, and how a lot of times when we talk about initiatives like the war on drugs, the support not just comes from the white community, but from communities of color. And how I was wondering whether we can take that rage that we feel towards these high crime rates or supposed high crime rates within our communities and turn it into a more constructive or productive manner, and particularly how we, and I think I speak for a lot of people here today, can use the rage that we feel espoused by your talk to work within a system and potentially work within a system that has the potential to produce more violences against these communities?
It's a great question. And one of the great things about your question is it points out, as difficult as it is, how we have to listen to multifacets of these conversations, right? It's not like I can, when I had more free time, which translates to when I didn't have children, I used to spend much more time in political conversations, in town halls, in community board meetings. And it always reminded me to be humble, right? That it's not for the law professor whose life is actually quite good to simply say, oh, you wouldn't want that, or you wouldn't accept. There are people in distressed communities that are asking for a lot of interesting things to which we must listen, especially if we're going to be in positions to make demands. Now, what did hearten me, to your point about internalized racism, most of the time when you listen to people, they're not saying things that are actually all that self-defeating, rarely, right? So, when I'd be in board meetings about places with public housing, for example, the complaints were that they wanted police to stop people from coming and going who weren't supposed to be there, or even stop people from, urinating in hallways, or not typically hallways, but doorways. I mean, it's not as though they lived in a la-la land. This was their real life. But what was really always true is that, the way I've always put it, it's not like black people want more police. Black people want good police, right? These communities wanted good. So what would they ask for? We want the door fixed. That's the first thing we want. We want the door to lock. We want the video above the door to work. We want the keys to work. So one of the things we have to remember is often it's the case that when communities that are most vulnerable acquiesce to what looks like the demands of internal racism, we'll just take the police. It's often because they're given no choice. It's often because somebody says, well, look, we're not gonna build new schools. We're not gonna give you the job training. I can't tell you how many times I heard people say, you know what would help with our crime rates? Job training programs. Well, we're not gonna give you that. Well, yeah, okay. If all you leave me is now nothing or the police, it's not surprising that people will ask for police. So I think our job is not to give in and let people say, well, look, everybody agrees they want more police. It's just not true. It's to hold people to actually listen, to say, look, what would you want in your community, right? Well, why can't you hear that in this community? Right? I mean, this community board is asking for a job training program and for the locks to work, and then more police. Why is it that the only thing you hear is more police? I think that's a way of channeling our rage to make people listen, actually listen to those communities, including sometimes reminding ourselves to listen.
Any further questions? Yes.
Thank you. You're probably somewhat familiar with carding in Toronto. And my question is primarily about everything that you've mentioned about the warm beating heart that can help institutions. And what I'm seeing overall is more and more as our justice system becomes an android, it's privileging specific types of knowledge that are, I would say, oppressive. They are created and they are used for future crime to a certain extent. If we think about Compass, if you've heard about it, uses analytics and algorithms based on certain attributes of people to predict their sentencing. And I think ProPolitico did a very big investigation into this to show that it was being discriminatory against colored populations, against minority populations. And so my question is for you is, as we see these extrajudicial or extra public players coming in and entering into our justice system, how do you see that from a philosopher of like, what are the things that can be done and how should these people be held accountable for the actions that they're taking on our public lives?
Yeah, I'm deeply distressed by the privatization of our criminal law system, right? And the most obvious example have been some prisons being privatized. But I absolutely agree, that's not the only place. You see increasingly in our rush and our love of technology to have smarter government, something which we should all support, the hiving off of what we might think of as essentially public functions. And this is something as a citizenry we just cannot allow, right? Punishment is not just about preventing bad things from happening, though it obviously is importantly about preventing bad things from happening. But if you believe, like I do, you asked me as a philosopher, if you believe like I do, that the very thing that gives us the right to punish somebody is that they violated our civic bonds, then it turns out to be true that the very thing that gives us the right to punish them obligates us to reincorporate them, right? And that means it's public in and public out. That is to say, the only reason I can punish you is because you have attacked our civic bonds, but I must restore those civic bonds, including letting you back in to the community. And that can't happen if I just turn you over to a private revenue generating source that cranks you through as a customer and then spits you back out. That is just the wrong way to conceive of fellow citizens. So if you ask me what my philosophical view, I actually think those things are just flatly illegitimate. And if you tell me it's the case that they save money, I'll tell you it's still illegitimate, right? There are lots of ways I can save money by doing illegitimate things, right? But that's not what punishment is. So I think we really as a citizenry need to bond and just refuse these kind of things. By the way, we also have to keep our eye open for the way in which private interests can corrupt public goods as well, right? So when prison communities become self-sufficient economies, such that you hear elected officials saying, we have to keep the beds full because this prison town will otherwise start losing business, that is a corruption of a public purpose, right? When you hear the wonderful documentary 13 was just released, and I certainly recommend it to you all. It's actually a much more general documentary than just about prison work. But one of its core points is when you allow prisoners to work without being paid anything, right? You thus create a private incentive to keep prison systems going. And it was very explicit why this was done post, it's part of the 13th Amendment, post-Civil War. There are lots of different ways we can cure these problems, but they depend on seeing these incarcerated persons first and foremost as our fellow citizens, right? So for example, paying somebody and putting it in a trust fund for them to get it when they're released from prison is a pro-citizen building way of punishing somebody. Exploiting them for cheap labor is exactly the opposite. Those are the kind of demands we have to make from our body politic.
All right, well, on this note, please join me in thanking Professor Ekow Yankah for a very thoughtful, thought-provoking speech. I'd like to say, Ekow, thank you for putting your personal turmoils aside, crossing the border, and coming to educate us. And your last intervention points to the fact that your talk was only about scraping the tip of the iceberg, right? You've talked about policing, a bit about court, but there are many other layers to the criminal process. We haven't talked about prosecutors, prison guards, etc. Right? So this is a serious issue. We're grateful that people like you are involved with them and confronting them for what they are. Thank you very much, and hope that won't be your last visit to Osgoode.
Thank you for having me. Thank you
Thank
very
you.
much.
Great.